and this will be a D series. And a short disclaimer is that this is not a final key. Today we will see about the key of IPO examination 22 paper 3, and this is not the this is only a tentative key, and the departmental key will be final for all purposes. For information's sake, this video is being done. The first question: the Code of Criminal Procedure 1973 came into force on 1/4/1974 is the correct answer. The Code of Criminal Procedure 1973 cognizable and non-cognizable offence has been defined under Section 2 C. 3. Complaint as defined in Code of Criminal Procedure means any allegation made orally or in writing to the magistrate. It is called as complaint, and answer is A under Section CRPC Section 2D. Next question: investigation of an offence as defined in Code of Criminal Procedure is conducted by police officer or any person so authorized to do under Section 2H of CRPC. Next question: a warrant case under the Code of Criminal Procedure means a case relating to an offence punishable with Section 2X of CRPC. The answer is all of the above, that is death, imprisonment for life, imprisonment for term exceeding 2 years. All of these are the under warrant case. Next question: which of the following statements is correct? Cognizable offence means an offence which is shown as bailable in first schedule or which is made bailable by any law for the time being in force. Cognizable offence means an offence for which a police officer may, in accordance with the first schedule or under any law for the time being in force. Cognizable offence means an offence for which a police officer has no authority to arrest without warrant. Under Section 2C of CRPC, B is correct. That is, the cognizable offence means offence for which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So, arrest without warrant is the meaning of that cognizable offence. Inquiry under Code of Criminal Procedure means under Section 2G of CRPC, inquiry, every inquiry other than trial conducted by this code by magistrate or court is called inquiry. Answer is D. Place as defined in Code of Criminal Procedure means a house, a tent, vehicle or vessel, or a house, building, tent, vehicle and vessel. The answer is D under Section 2P of CRPC. A proclamation of a person for a person absconding under Code of Criminal Procedure requiring a person to appear must be published giving not less than 30 days from the date of publishing such a proclamation. Under Section 82(1) of CRPC, it is not less than 30 days from the date of publishing the such proclamation. Under which section CRPC a person who is avoiding execution of warrant may be proclaimed as absconder? It is Section 82. Any objection to attachment of a property of an absconder by a person other than the proclaimed person should be made within, as per Section 84(1), it is 6 months from the date of attachment. If a proclaimed person under Section CRPC appears as directed within the time specified in proclamation, the court shall make an order extending the attachment, make an order releasing the property from the attachment, make an order of forfeiture, take steps to attach any property in the name of proclaimed person. The answer is make an order releasing the property from the attachment under Section 85(1) of CRPC. 13th question. A proclaimed person under Code of Criminal Procedure whose property has been attached can claim the property or sell the proceeds on appearance within 24 months of attachment as per Section 85(3). Next, Prevention of Corruption Act adopted in India is Act of 49 of 1988. The term public servant has been defined in which section of Prevention of Corruption Act? It is Section 2C. The answer is C. Next, Chapter 3 of Prevention of Corruption Act deals with under Section 7 to Section 16, it is offences and penalty. Habitual offenders under Section 8 and 9 and 12 of Prevention of Corruption Act are liable for imprisonment for a term as provided in Section 14 of Act. It is not less than 5 years extendable to 10 years under Section 14 of 18th question. In cases where Prevention of Corruption Act applies, is It applies other applicable laws also apply as per section 28. You will find. Next, under Revenue Act, Recovery Act 1890, who has been empowered for recovery of sums recoverable as arrears of revenue by the other public officers or by local authorities. As per RR Act 1890, Section 5 says it is collector, district collector. Okay, that is why we report to collector if any RR Act to be imposed. In Indian Evidence Act came into effect from 1st of September 1872. Next, section 1 it says about it. Evidence may be given in any suit or proceeding of existence or non-existence of every fact in issue, relevant fact. The answer is both A and B. You will find fact in issue and fact relevancy in the chapter 2 of section 5 of Indian Evidence Act 1872. Facts which form a part of the same transaction are relevant under section 6 of Indian Evidence Act. To preparation and previous or subsequent conduct are relevant under section 8 of Indian Evidence Act. D is correct. 24. Part 2, chapter 3 of Indian Evidence Act deals with facts which need to be provided. Facts of which court take judicial notice under Indian Evidence Act includes, that is, the answer is both A and B. All laws in force in territory of India and articles of war for India Army and Navy or Air Force under section 57.1 and 57.3. Facts of which court must take judicial notice, part 2 and chapter 3. If court is called upon by any person to take judicial notice of any fact under the Indian Evidence Act, may refuse to do so unless and until such person produces any such book or documents as it may consider necessary to enable it to do so. Under section 57.13 of Indian Evidence Act. Under Indian Evidence Act, all facts except contents and documents and electronic records may be provided by oral evidence. That our oral evidence must be direct. Both A and B. The answer is both A and B. That is C is correct. Under chapter 4 of oral evidence, section 59 and 60, it covers. Which of the following is not a secondary evidence under Indian Evidence Act? It is the document itself produced for inspection of court. That is the answer under section 83 of under section 63 of Indian Evidence Act. Provision related to private documents is contained in section 75 of Indian Evidence Act. Answer B. Petitions to higher authorities against the order of lower authority are liable to be rejected without investigation if they are submitted more than 6 months after the date of communication to the petitioner of order represented against. The period 6 months counts from the date on which the petitioner was informed of the original order to the authority. That is, B is the correct answer. Plaints and written statements in suits in any courts of civil jurisdiction by or against the central government can be signed and verified in respect of matters concerning the post department by all gazetted officers conversant with the case. That is volume 2, 127A. From volume 2 it has been given. Which of the following statements are true with respect to security deposits of employees? It is required of the specific classes of employees owing to their pecuniary and other responsibilities. This question is from Postal Volume 2, Rule 199, and even you will find it is on the it is fixed amount that cannot be changed from time to time. It is taken from the Chapter 5, Part 3. Deposits of security are to be credited to the government under head miscellaneous revenue if they remain unclaimed for 3 years after their refund becomes admissible under Postal Volume 2, Rule 260. You will find this one. And which of the following statements is true in case of inward foreign mail articles bearing counterfeit, fictitious or previously used postage stamps? It is Postal Volume 2, Rule 395. That says such article need to be received in a service registered covered to the office of destination along with a special advice in the form 10C. Answer A is correct. 35. At what stage of disciplinary proceedings are charges framed and a charge sheet issued for major or minor penalty in a prescribed format? It is Postal Volume 3 Rule. It is Rule 2B. There will be 4 stages of disciplinary proceedings, and first one is the preliminary inquiry, the second one is the charge sheet framing. And which of the following statements is true in relation to suspension of a government servant? The answer is, a suspended government servant continues to be in grade held by him immediately before suspension under Rule 17. Next question. An order of suspension made or deemed to have been made can be revoked at any time under Rule 23 of Postal Volume 3. Many questions have been given in Volume 3 also, because it is the heart of CCS conduct rules also. CCA rules is also subsumed in the Volume 3. A government servant under suspension is entitled to a subsistence allowance from the date of suspension as per at the rate prescribed in FR 53. This is as per Rule 25 of Volume 3. Which of the following recoveries are compulsory from subsistence allowance? That is, repayment of loans and advances taken from government. They are compulsory. Rule 28 of Volume 3. On release of suspension, the period of suspension should be regulated in accordance with the provisions of FR 54 under Rule 39 of Volume 3. The charge sheet to a delinquent official should be served in either English or Hindi as per Rule 70 of Volume 3. So the following is true regarding appearing of government servants as witness in any inquiry inquiry against other government servant or against an employee of municipal committee or other local bodies. They cannot refuse to appear as witness if summoned by the inquiry authority under Rule 91A of Volume 3. They have to go. The penalty of withholding an increment takes effect from the date of increment accruing to the officer after the issue of the punishment orders. So it is answer B is correct, and Rule 102 of Postal Volume 3 says about this. An appeal against a punishment order under CCA Rules 1965 can be preferred to an appropriate appellate authority within 45 days of receipt of order by the appellant authority. Rule 122 of Postal Volume 3. Under provisions of administrative instructions below FR 29A, a permanent post vacant by government servant reduced to lower service grade or post or to a lower time scale should not be filled substantially until expiry of 1 year from the date of such reduction as per Rule 139 of Postal Volume 3. The records of disciplinary and appellate proceedings should be retained for a period of 25 years as per Rule 154 of Postal Volume 3. The extent of time specified under CCA Rules 1965 for anything required to be done under said rules or any delay therein can be normally condoned by. It shall be condoned by the authority competent to make any order under the rules. It is as per Rule 31 of CCA Rules 1965. Which of the following statements regarding preservation of records in a circle office is correct? Records pertaining to appeals should be preserved for 5 years after the month in which the cases are closed. Records pertaining to budget allotment should be preserved for 3 years after the year to which it is relates. Answer is only 2 is correct, and as per the appeals should be preserved for 3 years. Okay. As per preservation of records, you will find at 12.2. Records pertaining to tour programs in the office of head of the circle should be preserved for 6 months after completion of the tour. Preservation of records 12.2 within brackets 39, you will find there. And a license of posting of newspaper without prepayment issued by the head of the circle is recoverable at the discretion of the head of the circle on 7 days notice in writing. On issuing the 7 days notice in writing. This is from PO Guide Part 1, Rule 144.4 of 9. The half-yearly enumeration of daily number of ordinary unregistered letters and unregistered parcels given out for delivery is to be carried out during second week of February and August every year. So it is Rule 31 of Volume. The head of the circle may sanction transfer of a postal certificate standing in the name of minor to the of other person without any proof from court of law in cases where the guardian applying for transfer is a parent or a very near relative, as per Rule 65.1 of Volume 8. Okay. The memorandum book in the office of superintendent should be prepared by by the superintendent himself as per Rule 97 of Postal Volume 8. Inspection of post offices in the division being one of the main duties of superintendent of post offices, they should spend not less than dash days in a year in actual inspection. It is 100 days as per Rule 236 of Postal Volume 8. Entries in register of lines and stages maintained by Inspector of Post Offices in respect of their subdivision should be in the alphabetical order. These lines and stages will be maintained in M40 and Rule 291 of Postal Volume 8. It is mentioned in Rule 291 of Postal Volume 8. The different classes of records in inspector offices are disposed as per provisions of Rule 297 and 201 of Postal Volume 8. According to the CCS Conduct Rules 1964, every government servant shall at all times commit himself to uphold the supremacy of constitution and democratic values. Yes, that is correct as per Rule 314. Maintain political neutrality, 317 of CCS Conduct Rules. Perform and discharge his duties with the highest degree of professionalism and dedication to the best of his abilities, Rule 3.1.21 of CCS Conduct Rules. So all of the above are correct. That is correct. The term government under CCS Conduct Rules 1964 refers to, it is central government only under Rule 2 of CCS Conduct Rules 1964. According to the CCS Conduct Rules 1964, which of the following necessarily require previous sanction of the government? What is that? Honorary work of social and charitable nature, 15.2a. Occasional work of literary and artistic or scientific character. Negotiate for or undertake any other employment. Participate in sports activities as an amateur, 15.2c. These are the relevant rules. However, requires previous sanction, it is C only, that is negotiate for or undertake any other employment. In such a case, previous sanction is necessary, otherwise intimation is enough. Next one, which of the following is correct in connection with the transactions of immovable property by the government servant? It is previous sanction. Acquisition of immovable property by any means requires previous sanction. It is not correct. Sale of immovable property to any party requires previous sanction while it is not required in case of acquiring property. It is also not correct. Previous sanction is required for obtaining property in the name of members of the family. That is not correct. Previous sanction is essential only when the transaction is with a person having official dealing with him. This is correct. Previous sanction, you should understand 2 points. Previous sanction and intimation. These are two different words. Previous sanction means you have to apply first, then the government should say yes, then only you should go forward. That is called previous sanction. Mere intimation means you will purchase a property, then you will just intimate on completion of the transaction. That is called mere intimation. Here previous sanction is required whenever there is a transaction is with a person having official dealing. Mere intimation is sufficient in all the other cases. Okay. Here it is given previous sanction, so it is wrong. Here also previous sanction is required for obtaining property in the family name. That is wrong. Here also previous sanction for acquisition of immovable property. These are all wrong. Previous sanction is required whenever there is official dealing. Mere intimation is sufficient for procuring for acquisition of immovable property either in your name or your family's name. Central Civil Service temporary service rules are in force with effect from 1st May of 1975. Section 1-2 of CCS Temporary Service Rules 1965. CCS temporary rules shall apply to railway servants, government servants engaged in contract, persons who are employed temporarily in work charged establishments and who have opted for pensionary benefits. Under section 132 of CCS temporary rules, C is correct. The period of notice for termination of temporary service either by government servant or appointing authority is B, 1 month. As per 5B of CCS TS rules 1965. Which of the following statements is true under CCS temporary rules? When action is taken under Rule 5 to terminate services of temporary employee, reasons should not be mentioned. Rule 5 is applicable for termination of services of of pension and probation. Both are correct. First one is correct according to 5 GID 2, Government of India Decision 2 of CCS Temporary Service Rules 1965. Second one is correct, 5 Rule 5 of GDS GID 8 of CCS Temporary Service Rules. Any order of suspension made or deemed to have been made under Rule 10 of CCS CCA rules should be reviewed by the authority competent to modify or revoke the suspension within 90 days from the effective date of suspension. This is as per Rule 10.7 of CCS CCA Rules 1965. 90 days it should be reviewed. So the following is a minor penalty: reduction to lower stage in the time scale of pay by one stage for a period of not exceeding 3 years without cumulative effect or not adversely affecting the penalty. Withholding of increments, this is minor penalty. This is also minor penalty. Reduction to a lower time scale or grade or service to a specified period in the order of penalty, which shall be a bar to the promotion of government servant during the specified period to the time scale of pay or grade which was reduced with the direction as to whether or not promotion of expiry of period specified. This is the major one. And removal of service which shall not be disqualification for future employment under section 2 of CCS CCA rules 1965. This is correct. Rule 13 of CCS CCA rules 1965 deals with the discipline authorities, types of penalties, suspension, authority to institute proceedings. Answer is D. The procedure for imposing minor penalties is provided in, it is in under Rule 16. Rule 16 is a minor, major is Rule 14. Under CCS CCA Rules 1965, appeal may lie in which of the following cases: an order of suspension made, deemed to have been made under Rule 10. In such a case, appeal may lie, and Rule 23 of CCS CCA Rules it specifies. Orders passed in appeal are to be given effect by. If any doubt arises as to the interpretation of any of the provisions of CCS CCA rules, the matter shall be referred to the President or other authority as may be specified by the President by general order or special order. Rule 35. The GDS Conduct Rules 2020, Engagement Rules 2020 came into force from 14th February 2020. Directorate letter number 17-30 2019 GDS dated 14/2/2020. GDS are extent rules. As per extent rules are three types: BPM, ABPM and Doc Sevaks. Rule 3D of GDS Conduct and Engagement Rules 2020. Members of family in relation to GDS includes wife, child or stepchild of such a sevak, whether residing with him or not in relation to sevak, who is a woman, the husband residing with her and dependent on her. Rule 3H of GDS Conduct and Engagement Rules 2020. Which of the following is not correct with regard to the terms of engagement of GDS? The sevak shall not be retained beyond 60 years of age. Rule 3A of GDS Conduct and Engagement Rules. Residence in post village or delivery jurisdiction of post office is mandatory within 1 month after selection but before engagement. Rule 3A7 of GDS Conduct and Engagement Rules. Failure to reside in place of duty by a BPM is violative of conditions of engagement and makes him liable for disciplinary action under Rule 10 of CCS Conduct Engagement Rules. Rule 3A7 of GDS Conduct Engagement Rules also specifies the same. The minimum and maximum age of for the purpose of engagement of GDS post shall be 18 and 40 years respectively as on the date of notification of vacancy, with relaxation permissible as applicable. This is mentioned in Rule 3B 1 of GDS Conduct and Engagement Rules. The age relaxation applicable to persons with disabilities belonging to scheduled caste and scheduled tribe is basic computer training for all GDS is basic training. It is either 1 or 2 above. Each a basic training course certificate of at least 60 days from the computer training institute run by the central government or state government, universities, board or private institutes, or you can have the study computer as a subject in matriculation or 12th class or any other higher education. So this is Rule 3B 2 3 of GDS Conduct Engagement Rules 2020. The time related continuity allowance payable to GDS A BPM and BPMs range from, it is 10,000 to 14,500. Rule 3BX of GDS Conduct Rules, GDS Conduct and Engagement Rules. Which of the following categories of GDS applicants is exempted from payment of fee on online engagement process? It is all female employees. Latest recruitment, Directorate Letter number 17-23 2016 GDS 25/4/22, and point number 14 you find, and the rule 3B11 of GDS Conduct and Engagement Rules also you will find. Next is 83. GDS are entitled to gratuity, severance amount, or SDBS as the case may be decided by the government from time to time. It is the rule 6 of GDS Conduct and Engagement Rules. GDS may be granted paid leave of 20 days in a year, excluding 5 days of emergency leave in each calendar year. It is as per rule 7A of GDS Conduct and Engagement Rules. Minor penalties applicable to GDS are provided in Rule 9.1 to Rule 9.5 of GDS Conduct Engagement Rules 2020. An appeal against a put-off duty or imposing a penalty should be preferred by a GDS within a period of 3 months from the date on which the appellant receives a copy of order appealed against. It is Rule 14 of GDS Conduct and Engagement Rules. The casual laborers grant of temporary status and regularization scheme of Government of India came into force with effect from 1993. Rule 2 of casual labor grantor of temporary status and regulation scheme 1993. In case of Department of Posts, the scheme of casual laborers grant of temporary status and regulation came into force with effect from 12/4/1991. You should understand that this department it has come before the DOPT order. 93 it is 91. That is why they have asked this question. The grant of temporary status under casual laborers grant of temporary status scheme of Government of India entitles them for wages at daily rates with reference to minimum of pay scale for corresponding to regular Group D official. 87 1993 is as per DOPT OM number 51016/2/90 STT C dated 10/9/93, and 88 12/4/1991 it is as per Casual Labor Grant of Rules Scheme Wide Directorate Letter number 45/9/87 SPB 1 dated 12/4/1991. Okay, this you will find, if you want the memo to be seen, these two things you will find in the Establishment and Administrative Norms by Swami's big book will be there. In that you can find this. 89 is with reference to Rule 5.1 of DOPT Casual Labours Scheme 19 Temporary Status and Regulation Scheme 1993. The short title of a Code of Civil Procedure in India is Code of Civil Procedure 1908. The Code of Civil Procedure in India came into force with effect from 119 to 1909, and the Act is of Act number of 5 of 1908. The following is correct definition as per Code of Civil Procedure Section 2. Decree holder means a person, any person in whose favor a decree has been passed or an order applicable of execution has been made. So this is as per Rule 2.3 of Code of Civil Procedure Section 2. In the Code of Civil Procedure in India, the High Court in relation to Andaman and Nicobar Islands means High Court in Calcutta, as per Rule 2.7a of CCP 1908. In the Code of Civil Procedure, order means the formal expression of any decision of civil court which is not a decree. That is under Rule 2.14 of CCP 1908. In the Code of Civil Procedure, mense profits of property means those profits which a person in wrongful possession of such property actually received or might with ordinary diligence have been received therefrom, together with interest on such profits, but shall not include profits due to the improvements made by the person in wrongful possession. It is Rule 212 of CCP 1908. Section 1 of Indian Penal Code 1860 deals with the title and extension of operation of code. Which of the following is incorrect? The code does not apply to any offence committed by any citizen of India without and beyond India. This is as per section 4 of IPC 1860. This is incorrect. Under which of the following situations would India courts have jurisdiction? It is section 2 of IPC 1860. All of these three are correct. That is, crime committed by foreigner in India, crime committed by India in foreign country, crime committed by a person on a Indian aircraft. In Indian Penal Code, punishments are dealt with Chapter 3. Chapter 2 relates to general explanation. Chapter 3 punishments. Chapter 4 general exceptions, and Chapter 5 is abatement. Commutation of sentence of death under Indian Penal Code is covered under section 54. It is sentence of death. 52 is good faith. 53 is punishments. 55 is commencement of. It is common of sentence of imprisonment for life. Okay. Next, a sentence of imprisonment for life under Indian Penal Code can be commuted for a term of not exceeding 24 years under section 55 of IPC 1860. The maximum imprisonment under section 166 of Indian Penal Code relates to public servants disobeying law with intent to cause injury to any person is 1 year simple imprisonment. Shall be punished with a simple imprisonment for a term which may extend to 1 year, or with a fine, or with both. 103. Criminal breach of contracts of service under Indian Penal Code is dealt in. It is dealt in chapter 19. Okay. It is dealt in chapter 19. In APAR, the weightage given to assessment of work output is it is 40%. Personal attributes it is 30%, functional competency it is 30%. APAR guidelines circulated by the DOPPOM number 21011/1 2005 established ESTT A part 2. This is APAR brochure released on 14 May of 2009. Leadership qualities evaluated in APAR is a part of assessment of personal attributes. Next one, decision making ability in APAR is a part of assessment of functional competency. Which of the following is an APAR? In an APAR is an example of personal attribute. It is maintenance of discipline. It is as per DOPTOM dated 23/7/2009. Disposal of representation in connection with APAR by competent authority is to be done within 1 month from the date of receipt of representation. APAR grading good corresponds to numerical grading A and a short of 6. Okay. Then APAR grading graded below 4 are given as a score of D, that is 0. Representation against entries made in APARs are to be made within, it is 15 days of communication. 2.4 of A back page you will find on the APAR. The Administrative Tribunal Act was enacted by the Parliament in 36th year of Republic India. That Administrative Tribunal Act 1985, Act 13 of Article 13 of 1985, 27 to 1985 in preamble. Okay. The Administrative Tribunal Act is Act number 13 of 1985. Okay, this is the one. The Administrative Tribunals Act does not apply to, it is all of the above, any member of naval, military or of air forces of any other armed forces of Union. 2A, any officer or servant of Supreme Court or any High Court subordinate to thereto. 2C, any person appointed to secretarial staff or either House of Parliament or secretarial staff or any state legislature or house thereof, it is 2D. So there the answer is all of the above. It is not applicable to all of them. The term President in Administrative Tribunal Act refers to the President of India. The Central Tribunal Administrative Tribunal can be established under Section 141 of Administrative Tribunals Act. The Chairman of Administrative Tribunal shall hold office as such for a term of 5 years from the date on which he enters upon his office or till he has attained age of the jurisdiction and powers and authority of CAT are covered in chapter 314 section 14, and to the power to punish for contempt is vested in a tribunal as per the section 17 of Administrative Tribunals Act under chapter 3. You will find it. Applications to the Administrative Tribunal can be admitted after other remedies have been exhausted as provided in section 20 of Administrative Tribunal Act under chapter 4. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 came into force on 9/12/2013 by notification SO 3606E dated 9/12/2013. Under Sexual Harassment of Women at Workplace Act 2013, the term presiding officer means the officer of Internal Complaints Committee nominated under the subsection 2 of section 4. The term of office of members of Internal Complaints Committee formed under Sexual Harassment of Women at Workplace Act 2013 should not be more than 3 years. It is under section 4.3 of chapter 2. The complaint of sexual harassment is covered in section 9 of Sexual Harassment of Women at Workplace Act 2013. During the pendency of any inquiry on the written request made by the aggrieved woman, the internal committee or the local committee, as the case may be, may recommend to the employer to grant leave to the aggrieved woman up to the period of 3 months. Section 12 of chapter 5 states so. An appeal against the recommendations of internal committee or local committee under Sexual Harassment of Women at Workplace Act 2013 can be preferred to the court or tribunal in accordance with the provisions of the service rules. It is covered under section 18(1) of the Act. The appeal against recommendations of internal committee or local committee under Sexual Harassment of Women at Workplace Act 2013 can be preferred within 90 days of the recommendations. Under section 18(2) it is covered. Under Sexual Harassment of Women at Workplace Act 2013, the duties of employer has been defined under section 19. The name and territory of union of our country is India for urban India and Bharat for rural India. It is both India and Bharat for entire country. Here I think in the Hindi version it is given as ABCD. Here it is ABC only. It is as per Article 1 of Constitution of India. India, that is Bharat, shall be the union of states. 130. The term state in the part 3 of Constitution of India refers to all of the above. That is the government and Parliament of India, the government and legislation of each of the states, and all local and other authorities within the territory of India under the control of the Government of India. Article 12 of the Constitution of India. The right of equality is provided in for Article 14 to 18 of Constitution of India. D is correct. Protection of rights regarding freedom of speech covers the right to assemble peaceably and without arms, to form associations, to move freely throughout the territory of India. These three are correct. Article 19 of this one, C is correct. No child below the age of 14 shall be employed to work in any factory or mine or engaged in any other hazardous employment as per Article 24 of Constitution of India. Part 4 of Constitution of India deals with the directive principles of state policy. Force, the Supreme Court command of Defence Forces of Union is vested with the President of India. Article 56 of Constitution of India deals with the term of office of the President of India. B. The minimum age for election as the President of India is 35 years. Article 58B of Constitution of India. Every president and every person acting as president or discharging the functions of president shall, before entering upon his office, make and subscribe an oath or affirmation in the prescribed form in the presence of Chief Justice of India as per Article 60 of Constitution of India. The Council of Ministers with Prime Minister at the head of aid and advise the President is provided in Article 74 of Constitution of India. The Council of Ministers hold office during the pleasure of President. It is correct as per Article 75(2) and shall be collectively responsible to the House of People. This is also Article 75(3). Let us wait for the final key. There are two answers. The number of members nominated to the Council of States by President as per Article 81A of Constitution of India is C, that is 12. A money bill can be introduced. Establishment and Constitution of Supreme Court of India is provided in Article 124 of Constitution of India. Answer C. 144. Which of the following offices is held at the pleasure of President of India? It is Governor of State, Article 156 of COI, Constitution of India. The powers of High Court to issue certain writs is provided in Article 226 of Constitution of India. Part 8 of Constitution of India deals with it is Union Territories. Part 8 is Union Territories. Judiciary is Part 4. And Municipalities is 9A, Part 9A. Panchayats is Part 9. Services under unions and states are covered under Part 14 of Constitution of India. Part 12 is about the finance and property, contracts and suits. And 7th schedule is about union, state and concurrent lists. And 6th schedule 6 is about the provisions as to the administration of tribal areas in the states of Meghalaya, Tripura and Mizoram. Okay. Article 343 of Constitution declares Hindi as a official language of Union, and provisions as to the financial emergency as provided in the article of Constitution, it is 360. 352 is the proclamation of emergency. 355 is duty of Union to protect the states against the external. 50. The 8th schedule of Constitution of India includes how many languages? 22. So this is all about the paper 3 of IPO examination 2022. This is about a D series, and again the disclaimer is that this is not the final key. It's a tentative key for your education purpose only. The final key will be released by the department soon. Thank you.